I told you. You thought what? I told you that I was still on medication. And you are bringing in this young girl to me. What is the matter with you?
Chief, she was already in Lagos before I heard of your ill health.
Now that you know, import her. Import her. Now that you know, export her back from where she's coming from.
Dad, I was in court today, and it looks like nobody wants to testify again. The girl that I talked into testifying recorded a conversation and played it in court.
Oh my God. She did what? And what did you tell her?
All you need to do is get somebody to come here and lie. Lie, lie, and lie more. Lie until somebody like Akume Gombot is dead. Lie until Agozie is dead. Lie until Dr. Fashola is kicked out of the university.
School and the care to pass.
Some thinking. Where are you coming from? What did you go to do upstairs?
I didn't go upstairs to do anything.
Tuvi!
Listen, guys. We don't have time. Any moment from now, the judge will read his judgment, and I'm sure Chico will be free.
So what do we do?
I brought my father's gun. I have already instructed Akbos to get the address tonight, by all means. If he dies, the judgment will be stored for a long time.
Tuvi, count me out.
Fella, if we don't do this, we'll go to jail. Remember, I said we, not me. We, all of us.
But Tuvi, killing another person will not help us.
Then what will? Tell me, fella, what will save us? Reverend Fela Idahusa Kumuyi. With or without your support, I'm going to do this. And if I succeed, good. But if I don't, we all go in.
Never.
Musa, let's go. We get Apostle along the way.
Tuvi. I hope that's not what I think.
Defense counsel, you can now address the court.
Thank you very much, my lord. My lord, it is our submission that the accused person be discharged and acquitted on the following grounds inter alia. Number one, the accused person in his statement to the police pleaded a defense of alibi at the earliest possible time for enough time for the police to do their investigation. The IPO said during cross-examination that he did not bother to do so. In Yano vs. State, 1965, in ALL, Nigerian Law Report, page 193, and Umani vs. State, 1988, in the Nigerian Weekly Law Report, page 274, the Supreme Court ruled that the accused must raise the defense of alibi at the earliest possible time. He should also give the police the particulars of his whereabouts at that material time. Once this is done, he has discharged his duties. The Supreme Court went on to say that it is the duty of the police to investigate the defense of the alibi. In this case, the police failed totally, and therefore the accused person should be acquitted because the burden is on the prosecution to rebut the defense once pleaded. Number two, the accused claimed that the jacket was on the table in his room. He never wore it to the party. His evidence to the police showed his lock was not tampered with. And the prosecution witness number 1 confirmed this. My lord, let us paint a picture of how the jacket came to be stained with the deceased's blood. The killer, not the accused person, walked into the accused BQ room, lifted the footmat, picked the key, unlocked the door, picked the jacket, went on a killing spree, and came back and placed the jacket back in the room with the blood stain. Number 3, we should disregard the testimony of prosecution witness number 2 because of her myopia. From the demonstration in the court, believing her would mean that the killer was wearing not just a gray jacket, but a blue and red jacket at the same time, which is impossible. Also, she could not differentiate between the sound of a gun, which she claimed she heard, and that of a banger. On the grounds of inconsistency, the benefit of doubt should be resolved in favor of the accused person. Number 4, the evidence of prosecution witness 3 should entirely be expunged from the records of the court, and she should be tried for perjury and for giving false testimony in this honorable court in order to avenge a failed relationship. It is sad. We do not have much to say about prosecution witness 4, the doctor, only that he was negligent in his duties by letting an innocent man die in the guise of waiting for a police report. He was also negligent when he concluded that the deceased died as a result of a gunshot wound without carrying out proper medical autopsy. Although he admitted under cross-examination that it could have been caused by another sharp object. My lord, emphasis on another sharp object. We shall rely also on the ballistic report, which shows that the expended bullet is a police bullet and was shot by policemen during the clash 8 months ago between a secret society and its members and some members of the rapid response unit at the scene of the crime. My lord, we want to believe that there is a conspiracy by some unknown men, unknown forces, if I may be precise, to rope in the accused person. It is therefore our humble submission that the prosecution has failed to prove its case beyond all reasonable doubt, and also that the accused should be discharged and acquitted. Thank you, my lord.
Prosecution counsel, do you wish to address this court?
Yes, my lord. My lord, this is the address of the prosecution. The accused person in this court was charged with the offense of murder, contrary to Section 319 of the Criminal Code Law, Chapter 31 of the Laws of the Federation of Nigeria, Lagos area. In the prosecution of the accused, the prosecution called 4 witnesses, while in his defense, he called 3 witnesses. In his testimony, the prosecution witness 1, the IPO, told the court the details of his investigations, how he found the blood-stained jacket in the accused person's room, the recovery of the bullet shell, and the statements made to the police. Under cross-examination, the prosecution witness 1 told the court that the whole Lady Potter denied ever seeing the accused person the night of the murder. Prosecution witness 2 in her evidence told the court how she saw the accused leave the scene of the crime. She even identified the accused, although the lighting system in the court made it impossible for her to identify the exact jacket here in court. Also, it has been proved that guns make different kinds of sounds, and the prosecution witness too has sworn under oath and told this honorable court that what she heard was a gunshot and not the sound of a banger. Prosecution witness 4 admitted that the accused died as a result of the loss of blood due to the gunshot. Defense witness 1, my lord, had admitted he left the party to see his mother, while the police investigation revealed the contrary. Under cross-examination, the accused admitted that he is the only person on campus that owns the jacket found in his room. He also admitted that he had a quarrel in the past with the deceased and that he promised to give him a surprise package. Defense witness 3, however, in her evidence admitted that the accused once beat her up mercilessly after a minor quarrel, thereby confirming our earlier assertion that the accused is a violent man capable of anything. My lord, it is our submission that from the evidence, everything points to the accused person as the killer of the deceased. The bloodstained jacket, the violent nature and disposition of the accused, coupled with his unforgiving spirit, all indicate that he left the party to kill the deceased on the pretext of going to see an imaginary mother. My lord, it is our submission that the accused person be convicted for the murder of the deceased and consequently sentenced to death.
This case is adjourned to the 17th of next month. I rise.
Good morning, sir.
Good morning. How can I help you? And by the way, who let you in?
Yeah, security men. We identified ourselves as security officers.
So, can I see your ID cards?
That won't be necessary. Do you know Tuvi Uba?
Tuvi, yes, I know him. In fact, he's my son. Where is he?
I am Inspector Kuku of the Homicide Department. And we want you to come to the station to identify the body we suspect to be Tuvi's.
Body? What body are we talking about?
We found 2 dead bodies in a wrecked car along the express road. They were students of this university, according to their IDs. And on inquiries, we learned that one of them has been rushed to the hospital.
Bodies. What were they doing at the express road?
We also recovered a military gun, 2 empty bottles of brandy, which we found out they are drinking inside the car.
Well, as the national chairman of the ruling party, I'm also a retired brigadier in the army.
We know that, Chief. So, when did he take the gun and for what reason?
The gun he took yesterday with the car, but for what reason, I do not know.
Well, we are sorry about this, Chief, but you'll have to accompany us to the station to first identify the bodies and then make a statement.
To who? Make a statement to who? Now you listen to me, gentlemen. I do not want to see his body for now. And I am not in the mood to make any statement to anybody.
I'm sorry about this, sir, but we are acting on orders from above.
What above? What above, I want to ask you? Huh? We are the above. We are the above. No other is above us. Well, you listen to me, gentlemen. I will give you something for your troubles, and you'll go home. Tomorrow, I'll be at the station to make a statement. But for now, I want to see my son.
School and the care to pass.
Good evening, ma'am. I'd like to see Tuvi and Chief, one of your patients. I learned he was admitted here after being involved in an accident yesterday.
Sorry, cannot see him, sir.
Why?
The accused person is charged with the offense of murder, contrary to section 319, subsection 1, Criminal Code Law, on the 12th of May, 2009, at the theater building of the City University. The accused is alleged to have committed the murder with a gun. The accused, in his plea, pleaded not guilty to the charge. In support of the case, the prosecution called 4 witnesses, while in his defense, the accused testified for himself and called...
What is the situation now? I hope he's in a more stable condition for surgery.
Chief, to tell you the truth, I would say out of coma, yes. But being in a more stable condition, I would say no.